This is the current federal tax developments for the week of September the 2nd, 2025. Current federal tax developments are brought to you by your state society of CPAs. Ed Zollers recording again this week from here in Phoenix. And we have a few things that came up during the week we're going to talk about in this week's update. Beginning with a decision that came down late on Friday, which is the Federal Circuit Court of Appeals ruling that found that the limits on the executive's authority to impose tariffs. Now, it's not really an income tax issue, but we're going to talk about it because it is a tax issue federally. And we do want to talk about it because I suspect at least some people in industry and some of you have clients that may be impacted by the tariff situation. So we'll discuss basically where that goes. And initially, it's not really going to change anything. So we're going to talk about that too. So if you expect everything's changing next week or your client believes that, you probably have to tell them that no, it doesn't. We're also going to talk about the IRS finally got out some guidance on the One Big Beautiful Bill Act's changes to research and experimental expenditures, and especially the small business special election to amend the prior 3 years. We'll talk a little bit about those. We're going to talk about the Sixth Circuit gave another decision that regards the tax court's jurisdiction to hear equitable relief cases. So we'll talk a little bit about that and how the Sixth Circuit now has come into line with other circuits. So there are 3 circuits now that are agreeing that the 90-day deadline to file your tax court petition is not a jurisdictional issue. We'll see if the tax court now decides to give up their insistence that it is. We'll talk about an innocent spouse case, Walsh versus Commissioner, kind of look at how that one turned out. We'll talk about how a taxpayer ended up being precluded from being able to argue his liability in the court by having delayed too long in the process, and even delayed long enough that unfortunately he screwed up his ability to even go through a collection due process hearing and challenge the existence of liability because he knew about the problem, but he kept trying to deal with it otherwise, and things ran out. And finally, an interesting private letter ruling. The IRS tells us about a situation where essentially a taxpayer who was defrauded was given the right to roll over the balance that had been taken out of the IRA account and put into what he might have believed was an IRA account, but wasn't, and put that back into his IRA account within 60 days. Now, we'll talk about why, as a practical matter, this decision it's interesting, but there's one key fact in this decision that doesn't mean it doesn't apply to your client, but it means that your client's probably not going to be worth the bother to go ahead and pay and get such a ruling. So we'll talk a little bit about that as well. But let's start about that case that came down late on Friday from the Federal Circuit's Court of Appeals, that in the case of VOS Selections, Inc. versus Trump, where the Federal Circuit decides that there are very strict limitations on executive authority to impose tariff under the IEEPA. And specifically, in fact, in a concurring opinion, some of the judges who, were part of the majority ended up saying that, in fact, you can't do any tariffs under that provision. We also had 4 who dissented and believed that it was okay. So it's kind of an interesting en banc decision. And so we'll talk about how that goes. So let's talk about this whole background. And I'm sure everybody knows about this, but we'll go ahead and we'll give you the official line. So there are 2 groups, 2 types of tariffs, two sets. We've been through a few tariff runs. 2 sets of tariffs that were imposed by the president. One was a tariff that was dealing with trafficking. It was 25% on Canada and Mexico and a 10% on China, later increased to 20%. Ad valorem duties on nearly all products in response to a declared national emergency regarding opioid and illicit drug trafficking. And the second set were the reciprocal tariffs. Now, that was the big set, right? This was a baseline 10% ad valorem duties on imports from nearly every country, right? With additional duties of up to 50% and up to 125% for China to address trade deficits. Now, these numbers have varied and they've been backed off of. Various things have happened. The question here is not whether the numbers themselves are okay. Remember, the question of this case is whether there was any authority whatsoever to impose anything. That's the question in this case, not the amounts at this point. Now, the president claimed the authority was he invoked the International Emergency Economic Powers Act, the IEEPA, and that's found in Title 50 of the U.S. Code, Section 1701, and following, among other statutes, as the basis for these tariffs, right? Now, the Constitution, the question comes up, the division of power. Constitution grants Congress the exclusive power to lay and conduct taxes, duties, imposts, and excises, and to regulate commerce with foreign nations. Now, obviously, the Congress is not the White House, so, we have an issue. But it doesn't mean you can't delegate certain things. So now we get that whole interesting background. Traditionally, what's happened, this was done differently than it's been done before. Historically, Congress would set a tariff schedule, but they'd give the president authority to adjust rates that would be limited and would be specifically defined by statute. So historically, it's not been that Congress has always been the one to vote for exactly each tariff percentage and any changes in them and anything would happen. They have delegated that, to the president because it is kind of a foreign relations issue to deal with. So they've delegated some authority to do it, but they've always authorized the rates, or set the schedules and put basically guardrails on how far and how much discretion the president would have. Now, the Court of International Trade, the CIT, originally granted summary judgment, remember this a while back, we talked about that, to the plaintiffs in this case, holding that both the trafficking and reciprocal tariffs violated the president's authority under the IEEPA and permanently enjoined their imposition. Now, that'll be interesting. We'll get to the status of all that as we get later on in this. Now, the federal circuit first has figured out, did the CIT have jurisdiction? Because if they didn't, then their decision would be totally null and void. And then they had to decide, if they did have jurisdiction, what was the nature of their review of their decision? Now, the Federal Circuit asserted jurisdiction under Title 28 U.S. Code, Section 1295A5. And the Court of International Trade, essentially CIT, had properly held exclusive subject matter jurisdiction. That's where the case had to be heard. That was under Title 28 U.S. Code, Section 1581 I1B. And the basis for that jurisdiction, the executive orders in question purported to modify the harmonized tariff schedule of the United States, so HTSUS, you'll see it abbreviated as, which are considered statutory provisions of law if authorized, and thus arising out of a law providing for tariffs. Now, the court said the jurisdictional question, that is, whether an action arises from a tariff law, is distinct from the merits question, that is, whether the IEEPA actually grants the president the authority to impose the tariffs. But it said because the jurisdiction says the action arose from a tariff law, the CIT had the right to decide whether the president really had the power to impose those tariffs, because the justification was this came from a tariff law. Now, deciding that therefore the CIT had the right to hear the case doesn't mean they got it right. It just means they had a right to hear it. So now the Federal Circuit reviewed the CIT's grant of summary judgment. And the question is, how much discretion would they give it? In a case like this, because it really is just a matter of law, the review is going to be what's called de novo, which means it re-examined the legal issues, did not defer to the lower court. It's going to do its own analysis of the law and figure out if that worked, because the issue is clearly one of the law. Does the president have the power? Now, the IEEPA, in its text, authorizes the president during a declared national emergency to investigate, block, regulate, direct and compel, nullify, void, prevent, or prohibit any importation or exportation of any property. That is actually from the law. Now, the Federal Circuit affirmed the CIT's holding that trafficking and reciprocal tariffs exceeded the authority delegated to the president by the plain text of the case. We keep hearing plain text brought up by courts all the time now. Yeah, that is the key starting point. Please be very aware of that. We're looking at text is where people are going, because the Supreme Court has been going that way more heavily over time. So remember that. That's also a key thing to remember anyway when you're analyzing any tax law, is you've got to start with the text of the statutes, because the text of the statutes are essentially set the law. And if they're crystal clear, going back to the old, basically Germain versus Connecticut National Bank Supreme Court case from a number of years ago, If the law is clear, we don't care what anything else says. It's it. Now, what the panel said, the majority opinion, and it was a 7-4 opinion, the IEEPA does not ever explicitly use terms like tariffs, duties, or taxes. They're saying what the president is authorized to do by that law, which is what they were basing their ability to do this on, never mentioned those tariffs. Other statutes where Congress delegated tariff power have used clear and precise terms, like new or additional duties, temporary import surcharge in the form of duties, and have included specific limitations on that delegation. The court noted and cited cases where the power to regulate is constitutionally and statutorily understood as distinct from the power to tax. Granting the right to basically the executive office to regulate an activity does not mean they could establish taxes on that activity. That's a different issue. So it said the term regulate must be read in context of other verbs in the IEEPA to investigate, block, direct, compel, nullify, void, prevent, prohibit, none of which involve any monetary sanctions or actions or taxation. They're saying there is absolutely no authority here, and they are looking for a clear delegation of authority, and they're saying they don't find anything vague delegation of authority, is the claim of the majority, right? The court also held and brought in what the Supreme Court has called the major questions doctrine. The tariffs at issue were of vast economic and political significance involving trillions of dollars and unprecedented scope per the majority. Such transformative, which is a term they like to use, actions require clear congressional authorization, and this law doesn't have it. Congress needs to step up. And there is no historical precedent of any of the previous presidents, because this law has been in the books for a while, ever using the IEEPA for tariffs of this magnitude. So essentially, Congress needs to do it, is going to be the ruling of the Federal Circuit. It's not that you can't have these tariffs, but Congress has got to at least very specifically delegate the ability to impose these tariffs. At least now remember, this is the Federal Circuit's opinion. There is another court that I really expect will step up and give us a final answer, but we'll get there. Now, what the government argued was that Congress, when enacted the IEEPA, had ratified a 1975 decision in a case of United States versus Yoshida International, Inc. It's called Yoshida 2 as the reference here, that upheld a temporary 10% import surcharge imposed by then-President Nixon under the IEEPA's predecessor, which was the Trading with the Enemies Act. Now, what that case held, Yoshida 2, found that the Trading with Energy Act's regulate importation language did encompass the power to impose a temporary import duty surcharge. And, the administration says, look, regulate does allow tax. The predecessor did that. Now, the Federal Circuit, though, distinguished the answer of that case. It said that the court in Yoshida 2 had expressly limited and premised its decision on the very limited nature of the tariff that then President Nixon has imposed. It was a temporary measure. It was limited to articles subject to prior tariff concessions, and it was subject to a maximum rate that had been prescribed by Congress, none of which are true about the tariffs being imposed here. And it goes on to say the court in Yoshida 2 explicitly states it would not improve unlimited power or the president imposing whatever tariff rates he deems desirable. Okay, now, we'll get into a long discussion about whether that was dicta or actual law. Yeah, I guess it's a whole lot of fun discussion. But in essence, the court said, you shouldn't read Yoshida as simply giving carte blanche to impose tariffs. That, in fact, the Yoshida court even told you that's not what we're doing. Now, the court said in this case, the trafficking and reciprocal tariffs were unbounded in scope, amount, and duration, applied to nearly all articles from all countries, with ever-changing and high rates, on an explicitly limited duration by Congress. Therefore, these tariffs exceeded the express limitations of the Yoshida 2 holding and are therefore beyond the authority delegated by IEEPA. Now, to be fair, you'd have to remember that since the Yoshida court allowed those tariffs to stand, yeah, is it really relevant whether or not, because it doesn't matter if you're going to say their decision was wrong because, it wouldn't be limited. It was kind of irrelevant. The decision in front of them was, were these tariffs okay? That's really a key difference. But the court said, yeah, all Yoshida said is those tariffs are okay. Those tariffs are radically different from these tariffs. Okay. Now, important thing here, because this is kind of where we're going to go. The injunction of the Federal Circuit. So now, okay, great. Federal Circuit's great. So it means these tariffs don't apply. No. It said they vacated the permanent injunction that universally enjoined enforcement of the tariffs and remanded the case back. Now, there are a couple things here going on. And we'll talk about another issue involved in this too. That intervening, the Supreme Court, after the CIT issued its decision, and before the Federal Circuit got to its review, the Supreme Court had issued a decision case of Trump versus Casa Inc. that required lower courts to evaluate the propriety and scope of universal injunctive relief, considering the eBay factors for permanent injunctions. Therefore, CIT has to go back and see if a permanent injunction would still be valid, or if they can grant a more limited injunction, let's say, just to the plaintiffs in this case. Now, there are a few states that are plaintiffs in this case, so it would seem even a limited injunction probably totally unworkable. Like Arizona was one of the plaintiffs, so does that mean, if the products come into Arizona, no tariffs can be done? If the products are destined for Arizona, no tariffs can be imposed, and how would we regulate that? While if they were destined for another state, let's say that in fact didn't join, I don't believe Utah did, is it like, well, but they could collect the tariffs on Utah? Yeah, it seems like it's going to be a little fun to do that, but nevertheless, that gets it there. And in any event, actual enforcement of whatever they do would be deferred until October 15th, basically at the earliest. And that's because everybody knows this is likely going to be appealed to the U.S. Supreme Court. Remember, it's already been heard en banc by basically by the Federal Circuit. That means they brought all the judges in to hear this one. So usually we would have a panel and we would come back then and go to en banc. If somebody wanted to appeal the decision, they could ask for en banc rehearing. That's not going to happen this time. They could ask for, the opinion to be reconsidered. That's unlikely to happen. So probably this is going to the Supreme Court. And essentially, we would expect the administration to file there. And we would expect, and I really suspect the Supreme Court will grant cert. And I wouldn't be at all surprised if they, hold any changes pending their ability to hear the case and rule on the case. Now, there were concurring opinions, okay? We had a concurring view voted by justice. Remember, some of the judges, now remember, concurring means they agree with the result. And all the concurrences did here was add to what was said by the general opinion. Now, it tells you right away that all the judges that signed on the main opinion were not comfortable adding this portion. So it meant that everybody would sign on to the majority opinion in that result, but the logic is split. A chunk of the panel, a chunk of basically those who voted on this case, they argued that, in fact, the IEEPA doesn't authorize any tariffs whatsoever, not just limited ones. In essence, they're going to say, no, Yoshida does not. Yoshida was wrongly decided. It's not applicable under this case, under this law, etc. Regulate in the plain text, and I think part of the argument would be, look, when Yoshida was decided in the 70s, we weren't using this absolute plain text, hard and fast test. Now we're using it. They're saying that plain text does not encompass any way to raise revenue. And they said the government's interpretation would render other powers superfluous and would represent an unconstitutional delegation of taxing authority. So in essence, there's a chunk that says you simply can't do it. Now, there is also a, dissenting opinion, right? 4 judges ran in with this. They believe the language confirmed by history does authorize tariffs to regulate importation. They said regulative importation naturally includes tariffs as tools for controlled imports. And they said Yoshida was basically, that proved it was okay. It also said that the IEEPA has no textual basis for narrowing constraints on duration, amount, or scope adopted by the majority. They argued the major questions doctrine is inapplicable to foreign affairs context, where broad presidential delegations are expected and common, right? And they concluded that IEEPA's delegation of authority is constitutional under the intelligible principle test, especially given the foreign affairs and national security context. In any event, this whole thing is almost certainly going to the U.S. Supreme Court. As I noted, specifically to give time for the Supreme Court to consider stepping in, none of this, no matter what CIT does, would take effect before October 15th. And most likely by that date, I would be surprised if the U.S. Supreme Court had not accepted cert. Basically, so that they're going to hear the case. They'd granted cert. And I also think that they'll probably put an order in that will keep the status quo in place pending the Supreme Court hearing of the decision. So we'll just have to kind of see where all that goes. So in any event, keep aware, but obviously don't expect anything to change next week. Next up, a big one, Revenue Procedure 2025-28, issued on August the 28th. This is basically a ruling on implementation issues for the OB3s, Research, Experimental Expenditure changes that were made. Right. So, OB3, One Big Beautiful Bill Act, Public Law 119-21, 13 Stat 72, signed into law on July 4th, 2025, had significant changes to the tax treatment of research or experimental expenditures. It was meant to go back and undo a provision of the Tax Cuts and Jobs Act that required these expenses to be capitalized. Now, as I've said since the TCJA first passed, that was a provision that everybody expected would be repealed before it ever came into effect. But due to a lot of, almost a comedy of errors and a bunch of odd things, the fact that there was both a Republican push to get rid of it and a Democrat push to get rid of it. It was actually in bills that passed the House in both cases and never actually got past the Senate level. Got either stripped out of the bill, and basically it was money raising for that purpose, in order to basically, get the bill's cost below a certain level for what was in the Inflation Reduction Act, or it just never got passed at all. So when OB3 came, we did go back and fix this in a somewhat retroactive fashion. That's the other weird part about this. We didn't quite do it terribly straightforward. Revenue Procedure 2025-28 is what you need to look at if you're trying to navigate all of this, right? What it is, right? So it's going to address the elections and change in accounting method that were authorized by OB3, right? So prior to OB3, the Tax Cuts and Jobs Act rules, research and experimental expenditures paid or incurred after December 1st, 2021 were capitalized and amortized over 5 years for domestic research and 15 years foreign research. Now, that ends as of January 1st, 2025 because OB3 changed the law as of that date. Okay. Now, Revenue Procedure 2025-23 that was issued earlier this year was the automatic change in accounting method of accounting procedures. So what happens is this RevProc, in addition to doing a few other things, will essentially add new provisions to the automatic change of accounting methods. So you'll see references to Revenue Proc 2025-23. That's going back and essentially changing how you get automatic permission to change your accounting method, something we need for these changes in the law. Now, OB3 creates distinct treatments for foreign and domestic research experimental expenditures. So amended Section 174 deals now only with foreign research experimental expenditures, right? We have to still, those that are done, in essence, outside the U.S., we had regulations published last year that define what's foreign R&E, and that appears to be what they're using. They knew those regs were there. That appears to be what we're relying upon at this point. You have to amortize those over a 15-year period. Okay. And we also changed it so no deduction or reduction amount realized permitted if the foreign research experimental property is disposed of, retired, or abandoned. Amortization must continue for the full 15 years. And again, these new rules are effective for amounts paid or incurred in years beginning after December 31st, 2024. Obviously, strong incentive to not use foreign R&E, to not do it outside the U.S., or if you are using a contractor and you get the right, you have the risk. In essence, you got to go through the regs about a situation where if you hire a contractor, you'll still be the party that would claim the deduction or credit for R&E. You got to make sure, essentially, you have to worry about the fact if that's outside the country. You may want to have to insist that they have to perform those activities inside the U.S. so it's not foreign. Now, domestic R&E is covered by brand new Section 174 Cap A. That allows a current deduction for domestic research experimental expenditures paid or incurred during the taxable year. It's Section 174 Cap A. There is an option if you want to elect to capitalize and amortize these over a period of not less than 60 months. That is Section 174AC1. If you decide to elect to amortize, it begins in the month the taxpayer first realizes benefits from such expenditures. And software development is still considered a research experimental expenditure for Section 174 purposes, 174A purposes. And again, 174A generally, we'll get to an exception here, but generally it applies to amounts paid or incurred in taxable years beginning after December 31st, 2024. That was the change in OB3. Now, how do we make the elections? Let's talk about the 174 Cap AC election, right? That's the election to amortize, right? We're going to amortize domestics over a period of not more than 60 months. To do this, you attach a statement to the original federal income tax return for the first year it will apply. You made this election. The statement must be titled, filed pursuant to Section 6.02 of Revenue Procedure 2025-28, has to include taxpayers' detail, the election year, declaration of capitalization or amortizing, and how long you're going to amortize it for. Now, once you make this election, that method and period must be consistently adhered to for all subsequent years unless you get the IRS's approval to change your treatment. So if you decide to go down the amortization route, it's a permanent election, right? You would need to go get permission, and I don't recall anything telling us how we get that permission in a simple way, except going back to the service and asking for that permission. So you'd have to get approval for your change in method. Now, OB3 also changed Section 280C, Cap C, C1. Domestic research experimental expenditures are reduced by the amount of credit allowed under Section 41A. So essentially, that's basically getting it working the way it used to, or getting the way it works, because again, we're going to reduce the amount of the expenditures by the credit under 41A. We take the research credit. And OB3 made no changes to 280 Cap C, C2, which allows taxpayers to elect to reduce credit in lieu of reducing R&D expenditures. That election is irrevocable, but we are going to have some relief provisions when we get to small business options for this. Okay. Now, generally, these rules apply to R&D expenses paid or incurred in taxable years beginning after December 31st, 2021, and before January 1st, 2025. I should say, these we're going to talk about from this point, are those already capitalized amounts. What you capitalize your calendar year in 22, 23, 24. How do we deal with those? Now, remember, the law didn't go back and say we're just going to retroactively make them deductible, so that you'd go back and have to amend 22, 23, 24. Under the general rule, and please remember, everybody can use the general rule, you can elect to amortize remaining unamortized amounts in one of two ways. Either you can take everything in your first year that begins after December 1st, 2024. So you can just amortize it all right away, right? So calendar year taxpayer, all in 25. Or you can go over 2 years, right? So basically you'll do one half the first year after 24, the second half the second year in that rate. This election is treated as a taxpayer-initiated change in accounting method for Section 41A purposes, is applied on a cutoff basis with no 41A adjustments, right? Now, if you're a small business taxpayer, that's other than a tax shelter, you meet the gross receipts tax of 448C for its first tax year beginning after December 1st of 2024. That means average gross receipts for 3 prior years. This all ties out nicely because those 3 years are 22, 23, 24, are 25 million or less inflation adjusted. That inflation adjusted number for 2025 years is 31 million. So if the last 3 years, your gross receipts calculated under 448C's method of calculating gross receipts on average are less than 31 million, you're allowed to use the alternative small business taxpayer option. It is an election. You don't have to use this. You can go ahead and do the 1/2 each year option. But if you don't want to do that, you can go down this path. Okay. So if you do decide you're a small business taxpayer, you have some options. You can decide to retroactively apply the laws back to as if they had been in place or that law had said we're going to start this, for tax years beginning after December 31st, 2021. So all that would have happened in 22 is instead of being able to expense all R&E, we'd only been able to expense domestic R&E, and we've done 15-year amortization for foreign. If you want to go back and amend your returns, file claims for refunds under that scenario, you have a right to do so. So what you can do is you can elect to apply a new Section 174 Cap A and amended Section 280C to amounts paid or incurred in tax years beginning after December 31st, 2021. Now, that's your election. Some people have asked, can I just go back and get a refund from 1 year and then use the write off 1/2 each year for the other 2? No. This is all or nothing election. You make the election, you got to go back, right? The law says you're going to treat these things as being effective for years beginning after December 1st, 2021. You can then deduct domestic research spending expenditures or amortize them under 174AC in the year originally paid or incurred. Now, it seems a little crazy to go back and amortize them, but you could. You could make an election. It'd be really ridiculous to do it over 60 months, but okay, because we're kind of already there, unless you wanted to lock down the 60-month amortization. I've had some people ask if you could just keep doing it that way. I guess this is a way to keep doing it. You'd amend the prior returns, but you then put on the election to go over 60 months on the first year. But you'd be locked into the TCJA rules forever. I don't know many people that want to do that, but if you did, apparently you could do it this way. That election is made on a timely filed original return or administrative adjustment request or amended return for one of the applicable tax years, 2022 to 2024. Now, AAR is the interesting part. If you are a partnership and you didn't opt out of the Bipartisan Budget Act audit regime, either you couldn't because you have an eligible partner or you just didn't do it, you'd have to use the AAR, you'd have to use AR and all the BBA processes, which are a mess. I suspect that a partnership that would have to go down the BBE line, if it's a real large amount, maybe you'd be willing to go down and do a push out. But even that's risky if it's a big number because you can end up with a loss benefit under that scenario. And if you don't know how that happens, you need to go take a BBA course, about the audit regimes. But that's a very real possibility. And it's going to have to be a push out because presumably it will be a refund. So I have a feeling a lot of partnerships are simply not going to use the small business option. They'll use the general rule. General rule, all in 1 year. If somebody runs out of basis, okay, tough. But, if they run out of basis, then they'll carry it forward to the future, But in essence, this other option's there. And don't forget, that's it for everybody. You can just write it all off in 1 year. Now, the problem with that, if you are not a C Corp, is that we have tax brackets. And it could very well be a much less beneficial to be able to take it all in 1 year as to be able to go back and take it over the years, where you have higher brackets. Go back to the actual original years and do it the way it would have happened. Now, if you're going to file the returns under this ruling, you're going to make the small business taxpayer election, go to attach a statement entitled, filed pursuant to Section 3.03 of Revenue Procedure 2025-28 on our website. for currentfederaltaxdevelopments.com, and in the PDF I post on the website every week that goes along with this. We do have more information about what's in that statement. That'll be in there. So you can take it there. I also do. Anybody doing this, please go get the revenue procedure. Don't just follow somebody's summary, right? You got to make sure you're doing it the way the procedure says. So the best way to know you're doing it, the way the procedure told you to do it, is amazingly get the procedure and do it that way. So I'm just saying. Now, there is a due date problem here because of how Congress enacted this. It says you can amend through July 6, 2026, 1 year after date of enactment, which that falls on July 4th. July 4th falls on a Saturday. So essentially, July 6th becomes our day. But you can do the amendment by July 6th. But here's the problem. If you actually filed your 2022 return, let's say for the partnership, on, let's say, timely March 15th of 2023, your deadline is March 15th for that one of 26 because you're going to lose the statute. That is a 6511 refund claim due date. Go back and check your 23 returns before you decide you have until July 6th to do this work. What you may find is you only have until the date that the partnership return was filed. Remember, if you're on extension, that will mean also the date that basically the IRS received it. You don't get all the way to September 15th. So therefore, you wouldn't get all the way to July. Now, if it's clear it wasn't actually filed until after July 6th, then July 6th is your date. But that could trip somebody up. So be careful there if you have a client, especially one who always has their partnerships filed right on time. They don't ever want an extension. Yeah, you've got less time to fix those. Okay, that's part of here. Now, and here's what's nice. There was a real question because the law itself, basically the transition rule that's in the Act, you will not find this in the code, but in the Act, which is what authorizes this, had indicated you had to amend a return. Well, if you took that literally, it meant if you're trying to file your 24 return that was on extension, you couldn't. In essence, you had to do a 24 return amortizing your R&E expenses, and then go back and file a claim, then go back and amend that return to then come back and claim the refund. The IRS agreed with the AICPA suggestion that that's just dumb. So you are deemed to have made the election for an original return filed timely on or before December 15th of 25, as long as you deduct the expenditures on that return. So what I can do is I can file your returns on extension. I realize time's short now, but your partnership returns on extension, you can go ahead and file that return expensing the research experimental expenditures, as long as you apparently eventually go back and file those amended returns for the other 2 years, because obviously we got to do that too. So you just file it here and also file it as if you had already amended the other two, right? So you got to fix everything, but you can make this work. So you do not have to file an original 2024 1065 or original 2024 1120 or 1120 or 1120S, and then amend your way out of it. You can just file the actual, one that just does the expensing. And the November 15th date will also come up for a different reason. You also can change your election under 280C Cap CC2, which is the election that relates to the type of research credit options you're taking. You can change that election, which could very well be changed by the fact you're going to expensing now instead of using the amortization method. You go ahead and you can change that election. So that late election is irrevocable, and and if you revoke, you cannot go back and do it. So remember that, in essence, if you elected and now on your amended return you revoke that election, and then like 6 weeks later, say, oh, that was a dumb thing to do. Yeah, no, you can't go back and change it again. So, but you do have that option if you want to flip that choice. Automatic accounting change procedures are in place as well. Generally, they require the commissioner's consent. We have Form 315 to make a change of accounting method. But Revenue Proc 2025-28 modifies Revenue Procedure 2025-23 to provide automatic consent procedures for these various items. If you want to take domestic research experimental expenditures, for old 174 prior to 2025, you have change number 265 to do that, right? Domestic R&E for 170 Cap A post 2024, including transition options. There are cutoff base for first taxable year of 2024, change 273. And there is a waiver of 3115 in many cases for this. And for foreign research experimental expenditures, TCJ Section 174 and amended Section 174, right? The modified adjustment cutoff basis with change number 274. So you're still probably going to do some of these. Maybe you may still have 3115s to file automatic consent changes on the 25 return, right? But you want to be sure you take a look at those and see how they go. They're still available. Also, take a look at the cases where we can do a statement in lieu of then filing 3115. We got that. There also is a special automatic extension for some 2024 returns. This is for people that filed their returns on time, which means they can't file a superseding return by the due date that on the extended return would have been for the extended return, when it's kind of get them fixed. So you have a 2024 tax year that ends before September 15, 2025, which the original due date, excluding extensions, was before September 15, 2025. You can file a return, basically a superseding or information returns, can be filed solely for making the small business OBBBA election, late 280 Cap CC2 election revocation, or related method change, basically all the way through, essentially November 15th is going to be our deadline here. We talk about these accounting method changes, right? Whoops. Get that in there, right? So automatic 6-month extension. I should say not November, it's their part. So we're going to treat you as if you had done the extension, even if you hadn't, and you can still get your superseding returns in, right? So again, it'd be a 2024, so you're beginning in 24, that ends before September 15th of 25, and the original due date, excluding extensions, was before September 15th of 2025. So yeah, in essence, the original due date, excluding extensions, was before that date. You get the automatic as if you had extended to do a superseding return. And superseding returns are great, and information returns fixes, especially for partnerships. Like we said, if in some reason, now we still got the problem of the first 2 years, but you could do a superseding for at least the last year. So that is an option. Keep that in mind, okay? Okay, next up, we're going to go talk about this whole thing about when do we get, when can we ask for equitable relief for failing to timely file a, tax court petition for notice of deficiency. This is Aquendo versus Commissioner from the Sixth Circuit, case number 24-1205. It was issued on August the 25th of 2025 is when the opinion came down. Now, what the Sixth Circuit has ruled is whether the 90-day deadline to file a tax court petition to dispute a notice of deficiency is a jurisdictional requirement. We know the Supreme Court had ruled in a case last year that a similar, limitation on filing a tax court petition in the collection due process context was found not to be jurisdictional, and equitable relief was available. Right? In essence, the court had to consider that, they are allowed to consider equitable issues. And if you miss a 90-day deadline, if you have a really, really, really good reason, I mean, in this case, it's got to be really good, then, they can let the petition come in. Now, the Sixth Circuit had previously ruled that this was jurisdictional, but in the interim, the Supreme Court had issued that ruling in the collection due process case. The question is, was the Sixth Circuit going to say, nope, we think this is different? That was the tax court's position, that they think notices of deficiency are different than the CDP case. The statutes are different. Or would the Sixth Circuit say, nope, reconsidering what the Supreme Court said in that case and at least one others, that regarded a similar idea, not in the tax context, no, we think that you have to consider equitable relief. And the Sixth Circuit now agrees you do. They are now aligned with the Second and Third Circuits, which is an interesting number. When you have three circuits overturning a tax court decision, and so far no circuit having stood with them post-Supreme Court, will the tax court continue to assert this, or will they just throw in the towel and nationwide say, okay, equitable relief applies nationwide, and then it'd be up to the IRS to decide if they want to try to then, appeal that and have some other circuit decide, right? So according to this, for any case arising in the Sixth Circuit, the tax court must now consider equitable considerations, equitable tolling, when a taxpayer misses their 90-day deadline. So that review, that in essence, they reverse the dismissal of nationwide Aquinado's, petition for untimely filing. Now, the petition was mailed to the taxpayer for her 2022 return on May 30th, 2023. That notice of deficiency explicitly stated a petition deadline of August 28th. Now, she filed her petition on November 1st of 2023, which is 155 days, obviously more than 90 days after the notice of deficiency mailing date. Now, she requested equitable relief. She argued that first thing is that deadline should be subject to his equitable authority to exclude noncompliance. That is, 6213 is not jurisdictional. If it's jurisdictional, that 90-day deadline is set in stone, and I don't care what happened to you. Basically, unless Congress says if that happens, we'll give you an excuse, you can't get in court. Now, she claimed she had no actual notice of this issuance of notice of deficiency until October 10th of 2023, as that notice was sent to her former address. She also asserted that she had a lack of constructive knowledge. That is, even if you get the notice, if you became aware of the notice in time to file within 90 days, right, then that's a different issue, right? Because a notice of deficiency was not sent to her designated representative either. She had somebody on power of attorney, and they didn't send the notice to them either. She showed that she acted diligently by filing her petition 20 days after learning of notice of deficiency, and she contended the commissioner would not be prejudiced by the position. Everything except the first issue are all things that she would have to demonstrate, right? That she had no actual notice, she had no constructive knowledge, she acted diligently when she became aware of the issue, and that the IRS would not be prejudiced by allowing the case to go forward. So, but all really the Sixth Circuit's going to decide is the first one, because courts of appeals don't generally take up and decide factual issues. They'll send it back to the other court if they haven't thoroughly threshed out the factual side. Now, originally the tax court dismissed her petition for lack of jurisdiction. They said the Sixth Circuit said this is jurisdictional. So now the Sixth Circuit went to review this, right? And they again reviewed it de novo. As we said before, they're going to start from scratch. They're not going to grant and say we believe the tax court. We're going to basically start with the tax court's right, and we got to find a significant error. Rather, we're going to start from scratch and come up with our own decision. The analysis emphasized now with the current decisions, the high bar for labeling requirements is jurisdictional, and what the court calls a clear statement rule, where Congress expresses a clear intent that this thing be jurisdictional. So in essence, a jurisdictional provision describes a court's fundamental authority, subject matter personal jurisdiction, and cannot be waived. If it's a claims processing rule for orderly litigation, it may be waived or forfeited. You can consider these equitable relief issues. Now, prior jurisdictional labels in precedent were often less than meticulous, and lack the precedential effect on the true nature of the rule because they weren't decided under the way the Supreme Court says you've got to analyze this. Sixth Circuit said, so our prior precedent, we have to ignore that, right? We have to go now from scratch and consider, do we still want to stand behind that issue? Now, the text of 6213A says within 90 days after the notice of deficiency is mailed, the taxpayer may file a petition with the tax court for redetermination of deficiency. Now, the Sixth Circuit said, examining it, understanding how the Supreme Court now tells us to look at this, that language is noticeably absent of directives to the courts. Any reference to jurisdiction or any language that basically specifically outlines or limits a court's power. Instead, the provision speaks to what the taxpayer can do, not what the courts can do. You know, what the taxpayers and not the courts must do. Now, they're going to compare that to the Batchelor case, which was the U.S. Supreme Court's case in 2022, was collection due process deadline. Supreme Court found there the 30-day deadline for CDP review under 6330D1 was not jurisdictional, even though it has nearby jurisdictional language. Sixth Circuit said, as far as they're concerned, 6213A's text is even less indicative that it was meant to have a jurisdictional limit. You know, the jurisdictional language in 6213A is separate and relates to tax court's power, not the petition's deadline. So the court said it is difficult to make the case the jurisdictional reading of 6213A is clear, and we need that clear directive. Okay? So, hey, good news. Since the deadline is not a jurisdictional rule, it is presumptively subject to equitable tolling. Equitable tolling allows the courts to exclude a missed deadline when the failures arose from circumstances beyond the taxpayer's control. Right? In essence, you know, the notice went to the wrong place, didn't go to her representative, and so she didn't discover it until later. And that was beyond her control, that she wasn't able to discover it, is her argument. Where the court buys that argument is different. I will note that in the Batchelor case, within the last couple of months, we had that went back to the court and decided, and that court decided that, wait, you don't meet the high bar for equitable relief. So even though we have to consider it, we've considered it, we've rejected it. You don't qualify. Okay. But what the Sixth Circuit did was reverse judgment of the tax court and remanded the case back to the tax court for the tax court to consider her equitable holding standing. Does she have the right to go? Okay. Now, on remand, the tax court is to do the following: conduct a fact-intensive inquiry on a case-by-case basis, so looking at this case by itself. And it's going to look at a 5-factor test for equitable tolling. Going to look at her lack of notice of the filing requirement, her lack of instructive knowledge, was she diligent in pursuing her rights, the absence of prejudice to the IRS, and fifth thing that wasn't really commented on by her, in essence, was she reasonable in remaining ignorant of the deadline? You know, if you just bury your head in the sand and ignore evidence that something's going on, that's going to be considered, you know, kind of remaining ignorance. Now, her case looks better from my first glance than do the ones like Batchelor, because it does appear that she wasn't that late, right? In essence, it wasn't that late, and, you know, she can establish this. The only thing that may pose is going to be that last thing. Can she show that that she shouldn't have gotten clues, that there was an issue here? If she should have and she ignored them, then that's a different issue. So, you know, you got to see if the tax court's going to change its position on a 90-day deadline, or if we're going to have to continue watching for circuit appeals. But you know right now, if you're in the Second Circuit, Third Circuit, or Sixth Circuit, this is now available. Now, what does that change? Because most people listening to this are probably not attorneys, or even if you are, you know, a CPA or EA, you haven't taken the tax court exam, so you don't have the right to practice for the tax court. It does mean that if you get a client in who comes in with a notice after the 90-day deadline, or after the 90-day letter's been done, they missed the deadline, you have to at least consider, is this a case, you know, given the nature of what happened, is this a case, A, to be worth taking to tax court, and B, is their situation good enough to get in? And that means you have to at least consider whether they should first talk to a tax attorney about trying to get to tax court, because moving quickly, fixing the problem as fast as possible is one of the things you got to demonstrate to get equitable relief, or are we going to go? Now, again, if we're talking about $2,000, it's probably not going to be worth it to go to tax court. You're not able to, it's going to cost you more, especially when you have to demonstrate that you had equitable, basically that you qualify for equitable relief. That's probably going to be very difficult to do. But if we're talking about $200,000, then yeah, we might want to see about the equitable relief. And speaking of relief, we have an innocent spouse case this week. This is Walsh versus Commissioner. This is Lisa Marie Walsh versus Commissioner, Tax Court Memorandum Decision 2025-91. And the opinion came down on August 26 to 25. Okay. Now, this case for Lisa Marie Walsh offers significant insights into the application of Section 6015 relief from joint and several liability. Now, it focuses on the interplay of, the fact for equitable relief and the fact that she'd kind of been involved in some trials before, and, basically in this dispute early on and hadn't raised equitable spouse issues. Now, Lisa Marie and her then husband, Brendan, filed joint returns, and they maintained a very affluent lifestyle, right? And they had a long history of federal income tax noncompliance for the years 2011, 2016, including understatements and underpayments. Now, the IRS would later attribute most liabilities for 2012, 2014, and 2016 to Mr. Walsh, but portions of 2011, 2013 were clearly attributable to her, to Lisa Marie. Okay, that's how the IRS would do it. Now, there had been a prior deficiency case. They had a notice of deficiency 2011 to 2013 that went to the tax court. The Walshes that were represented by tax court filed a tax court petition, which led to a stipulated settlement and a tax court decision in 2019. The big issue was in this 2011-2013 deficiency case, the defense of innocent spouse was never raised in the proceeding. Now, that can get us into a real long question about whether or not there was a conflict of interest that should have been dealt with before representation moved forward, but that's a whole nother long discussion, and we don't have anywhere near the facts to understand, what went on there, if there was proper notice given, etc. Now, in 2017, she separated from her now ex-husband. Divorce decree in 2021 found tax liabilities to be joint and several, divided equally with indemnification. If one party paid more than half of what was due, the other party had to, make it up. And she also had a history of post-divorce noncompliance. Even after divorcing, getting away from Mr. Walsh, she filed a return late, 2017 to 2020 every year, had outstanding liabilities, and when she filed returns, she omitted income. So she doesn't have a clean record after that date, so that's kind of important. Now, she requested relief in 2020. She claims she didn't know if the returns showed balances due because she doesn't know how to read a tax return, and only learned of the extraordinary tax bill in January 2020. Kind of makes you wonder what the attorneys in the first deficiency case and her attorneys in divorce were doing, if this is the first time she heard about it. But okay, we're there. She also alleged she was emotionally and financially abused by Mr. Walsh, right, as part of the reason. Now, the doctrine of, and my Latin is not great, so we'll get there. Attorneys, forgive me, res judicia, judicata, whatever. You can't relitigate a cause of action after a final judgment on its merit has been rendered by a competent court. They said for 2011 and 2013, all of those are off the table because you blew your chance. There were 4 conditions to establish that. The parties were identical. She was a petitioner in the prior cases. The tax court had jurisdiction, so it was a court of competent jurisdiction. It was there. 2011, 2013. There was a 2019 tax court decision. It was a final judgment, the settlement, and the innocent spouse relief related to the same tax liabilities. So she's prohibited of whining about 2011, 2013. You had to raise this defense back then. You're now, years later, you're now coming back now and saying, I signed this last year, right? I don't want to do this anymore. I want to do it differently. Okay. Now, 6015 G2 only allows relief for the innocent spouse if the claim was not an issue in a prior proceeding and the spouse did not meaningfully participate. Now, she did not raise the claim. So the only question was, did she meaningfully participate? And obviously she's got to try to argue here, poor, pitiful me, I didn't understand, I was taken advantage of, whatever. Right. But the court found they didn't buy her line. She did meaningfully participate through counsel. Her counsel, she was signed on with that counsel as well, filed a petition, negotiated a settlement, and secured deduction for her business. And she said her testimony, she wasn't involved with this, was contradicted by evidence, including she directly talked with a revenue agent. How would you not know an exam was going on when you're talking to an IRS revenue agent? And the fact that she was not a, poor little unsophisticated person with a little education. She was financially sophisticated. Sorry, we think, if you were ignorant of what was going on, you were willfully ignorant, is basically how the court came to it, right? So because of that, the exception under 6015 G2 did not apply, so relief was barred for 2011, 2013. Right? What about 2014 to 16? Now, she sought equitable relief for 2014 to 16, as these years involved underpayments, not understatements, right? They weren't involved in the tax court thing. So now we look at analysis from Revenue Product 2013-34 that governs when you can get this sort of equitable relief. Now, first thing we look at under it, could you qualify, is look under the threshold, right? Was joint return filed? Yes. Was relief unavailable under 6015 B or C? Yes. Was a timely claim made for equal spouse relief? Yes. Were there any fraudulent asset transfers involved to try to move assets? Is the spouse going to get relief? No. Was there any knowing participation, fraudulent return? No. And was liability, attributable to his income? And yes. So she met this for those years. However, that's not enough. There is a streamlined method if you can meet three conditions, right? Your marital status, divorced or not, no disqualified asset transfers, and she faces economic hardship. Now, while she was divorced and there's no asset transfer problems, she did not establish this to be an economic hardship to pay her share of the tax. Her income, which is over $85,200 a year, significantly exceeded 250% of the federal poverty guidelines, and her claimed monthly expenses lack corroboration, right? She was not entitled to streamlined determination. And by the way, her economic hardship problem, that often is tough for clients to understand. I know you're used to living in, let's say a very, very, very nice big piece of property, a mansion at the really, really nice part of town. But you're not necessarily, that's not a right you get to stay there, or you get to qualify for that type of deduction item. You got to get through a lot of hoops to show that why that's what should be allowed for you, right? But she's not done yet, because that now, even though she can't get the streamlined method, we're going to go through 7 factors and, kind of weigh them. The court will determine if she should get equitable relief. And these 7 factors are found in Revenue Procedure 2013-34 in section 4.03, paragraph 2 of that section. And there were a number of factors that are there. We'll go through the ones first that weighed against giving her relief. Did she have knowledge or reason to know of the underpayment? She knew liabilities were owed. She signed the returns. They said, you sign the returns, there is an implied duty of inquiry to figure out what's on there. She was also very aware of his history of financial deceit and non-payment, right? The California Franchise Tax Board, attorney's fees, etc., hadn't been paid, right? And her abuse claims largely occurred after the separation, right? Wasn't during that time period. Did she get a significant benefit from not having to pay the tax? And yes, they enjoyed a lavish lifestyle. They had a $1.4 million home, country club membership, luxury cars. Kids went to an expensive private school. And as I said, this is all supported by not paying tax. It's a lot easier to pay for that stuff if you're not paying your taxes, which they did. And compliance income tax laws. Look, after divorce, she's still not complying with the law. She's treating them as kind of optional things to do. She failed to timely file Form 1040 for 2017 for 2020 with outstanding liabilities. She omitted significant taxable alimony income from her 21 return. And at the time they went to trial, she doesn't file a 22 return. She doesn't follow the tax law. So, that's a negative. If you're ignoring it after you're divorced, after you're away from this person, seems like maybe it wasn't all that person's fault, is the way the law kind of looks at it. Economic hardship was not proven. Now, in this case, that's a neutral factor. They're there. Legal obligation, divorce decree. Okay, so these are neutral factors. Divorce decree stipulated both spouses had equal obligation for tax liability. So that's neutral, doesn't go in favor or against her. And on medical or physical health, she was not suffering from mental or physical health during the relevant period. The only factor that weighed in favor of relief is the fact she's no longer married to him, right? But the court said, since only one factor weighed in favor of granting relief for all three significant factors, knowledge, significant benefit, and noncompliance. And I'll guarantee you, noncompliance is a huge problem, I think, for her. It's not, the court's just not going to like that, right? Because again, it goes to this whole theory of your case that you're the poor innocent person who was taken advantage of. Look, you went out on your own. Who did you think was going to file the returns for you? Right? And it's there. And you kept doing the same thing that it was showing up on the joint returns. So why should we believe you weren't aware of everything there? So they denied relief for 2014 through 2016. Next up, we're going to talk about a case where a taxpayer was precluded from challenging their liability in a collections case. This is the case of James D. Sullivan versus Commissioner, Tax Memorandum Decision 2025-92, which was issued on August 27th. Okay? You've got to go in the right procedural order when you're challenging IRS collection actions. Now, the first key rule about this is that a timely respondent to the 90-day letter is really crucial to preserving the right to challenge underlying tax liability. And in a collection due process hearing, you had to present concrete, viable collection alternatives during that hearing. And the problem is that, he didn't timely respond to a notice of deficiency. And we had all kinds of problems here. So his background, he's a retired U.S. Air Force officer. He omitted substantial income, his military retirement, and a state street retirement payment, which is much smaller from another source, on his 2016 federal income tax return. Kind of not smart to omit numbers, money paid to you by the federal government when you're filing your tax return with the federal government. Just saying that's a payer that might notice. They issued a notice of deficiency on June 10, 2019, determining deficiency and penalties. He received the notice, no question. He receives it. He indicates he got it, but he did nothing. That's not a good move, right? Ignoring it won't make it go away. I know a lot of people think that way, but especially people that have trouble paying their bills. I see that a lot. They just figure if they ignore it, it'll go away. And that works in some cases. And I think the real problem people get in with taxes is it appears to work for a long time in taxes until it suddenly doesn't. And they start getting serious about collection. Okay. After the assessment and non-payment, the IRS eventually issued a notice of intent to levy. Now, this got his attention, so he filed a collection due process request. Filed Form 12153, request for collection due process equivalent hearing, and he checked the box, I cannot pay the balance. He reiterated his claims about the income should be non-taxable, about the payments were properly allocated, and he didn't believe the IRS acted in good faith. Okay. He had been corresponding with them, but he just noticed deficiency. He didn't pay attention to the 90-day letter and filed in tax court. The settlement officer reviewed it. The settlement officer did discover that his action-related penalty had not been properly approved by the IRS supervisor. So the settlement officer took that off. So that number did go down. Uh, his submitted, though, Form 433A collection information statement demonstrated he had sufficient assets to pay the outstanding liability. That contradicted his statement that he couldn't pay. And his attempt to submit amended returns to retroactively spread income were withdrawn as frivolous. The settlement officer's termination sustained proposed levy, concluding the petitioner was precluded from challenging his initial underlying liability because he had a chance to contest and he just didn't do it. And he did not qualify for any collection alternative. He hadn't really asked for one. So bottom line, didn't get it. As a general rule, a taxpayer can only contest the existence or amount of their underlying tax liability at a collection hearing only if they did not receive a notice of deficiency for the tax year or otherwise had no prior opportunity to dispute it. Now, how that applied in this taxpayer, he received a valid notice of deficiency for 2016. So bingo. He failed to file a petition with the tax court within 90 days, even though he claims the amounts weren't taxable. That lost him the right to contest that liability before the appeals officer or the tax court at a collection due process proceeding. And the tax court, despite the fact that he couldn't do it, he still went to tax court trying to argue that he didn't that the money wasn't owed. In essence, he was trying to turn the collection due process proceeding into the chance to make up for the fact that he never got a 90-day petition filed. Yeah. When the underlying liability is not properly at issue, which is here, we only look for the abuse of discretion from the settlement officer. Now, the only way abuse of discretion occurs is if the determination was arbitrary, capricious, or lacks a sound basis in fact or law. And the court looks at a three-factor test found in section 6330C1 to 3. Did the settlement officer properly verify that all requirements of applicable law and administrative procedures were satisfied? Yes. They abated the penalty that wasn't properly followed, but left everything else in place. Did they consider any relevant issues that were raised by the taxpayer? Yes. But liability contentions were barred by 6330CB2 or were simply totally meritless. His reasons had no basis in the law in any way, shape, or form. And did they consider whether the proposed collection action balances the needs for efficient collection of taxes, any legitimate concern that collection activities be no more intrusive than necessary? Yes. The settlement officer explicitly concluded the levy met this. The petitioner failed to properly challenge this. Remember, the petitioner was solely focused on, I shouldn't be taxed on this. And that also happens. They don't consider, you got to have the backup if you are taxed on it. Let's assume if for some reason they decide you are, you're not conceding you're taxable, but you got to say if they do, then here's why I should have a collection alternative. You didn't go down that route, right? Also crucial for any collection due process hearing, you have to provide substantiated financial information and present a concrete, viable collection alternative to the IRS to consider. Despite claiming inability to pay, his Form 433A showed sufficient assets, right? He just checked the box and he checked something apparently. He did not submit any specific proposal for an installment agreement or other collection alternative. He didn't really say what the IRS should do. I mean, he was banking on, I don't owe any of this. And it's like, that wouldn't go anywhere. So the court said it's not an abuse of discretion for a settlement officer to reject collection alternatives as standard proposed collection activity where taxpayers fail to put an offer on the table. It's not up to the IRS to kind of, negotiate with themselves. In this case, we need, this is a negotiation. You need to put an offer on the table. And then the settlement officer can offer an alternative or maybe accept your offer. And the court did warn the taxpayer about a penalty under 6673. If he continued to make frivolous or groundless arguments for in a future tax court proceeding, he could be penalized up to $25,000. So the court suggests he doesn't do this. The tax court did grant the IRS's motion for summary judgment, sustaining the proposed levy to collect the taxpayer's unpaid tax. Finally, we have a private letter ruling that I understand why it was issued. I understand, I was a little concerned because technically the revenue procedure that the IRS relies upon for this didn't really seem to have a nice category this fell into, although the law did. But also, as we'll discuss and I mentioned ahead of time, I'm not sure this is practical for most of our clients. Not that you don't have, because I know of a lot of cases of taxpayers who have been scammed out of their IRA money. But the problem is, as we'll discover in this case, this taxpayer actually figured out the scam and jumped in fast enough that they were able to, with help of an agency, which I assume is law enforcement, to get everything reversed and sent back to the taxpayer. So he had the funds. The practical problem your client's going to have in most cases is they don't admit to the fact they got scammed, because it's really tough to do that until it's so late that the scammers are long gone. You know, basically, there's no way. Funds aren't still being held in process that can be quickly reversed, as they were in this case. But let's talk about this. So again, like all private letter rulings, we don't get names, we get assigned letters, numbers, etc. The taxpayer withdrew amount 1 from IRA X, right? So basically, taxpayer withdraws funds from an IRA on a certain date, date 2 in this case. The subsequent failure to complete a rollover in the 6-day period was directly attributable to an elaborate fraud scheme. This is kind of an interesting fraud scheme they did. The deception began when taxpayers A and B, husband and wife, received a computer alert, got a notice on their computer. Now, we're not told what that alert was. I suspect it would be like a pop-up on a compromised website. It says, oh my gosh, we're notifying you, that you got a big problem, right? So they contacted what they believed to be company A, right? Individual 1, who was a false representative of, quote, company A, claimed a virus had compromised a financial account and directed them, you need to call individual 2 at Bank A, right? So again, Bank A was basically, of where they were holding the funds. Now, of course, individual 2 wasn't really at Bank A, right? Individual 2, also a fake representative, did not work for the bank. Can you imagine that? And presumably, they sent them a phone number that also wasn't the bank's, which they called. Provide a forged letter to them and claim that their funds in Bank A were moved to secure locker accounts, right? That individual convinced the taxpayers to make 3 wire transfers of an amount 3, to various financial accounts, from various financial accounts to a cryptocurrency account for safekeeping while the fraudster was taken care of. And their funds would be therefore out of danger while they were in these crypto accounts. Okay, taxpayers bought into it up to this point. And while it may seem, how could they not see it was a scam by now? Once you get in panic mode, remember the initial alert on their computer, they call, oh my gosh, you had a virus, and then you call the bank, and oh my gosh, your stuff's in trouble. There's, your accounts are under attack. At that point, people stop thinking. What seems personally anybody else like you reading this is like, how could you not spot it? It wasn't your money. It's not your panic. Once you panic somebody, and scammers know this, once they can get the panic going, it's very easy to get people to do stuff. So on date 3, we got more dates we know. So we got amount 3, transferred amount 2, which included amount 1 from the IRA into the cryptocurrency account. So they got scammed for more than just the IRA, but they had funds from the IRA, right? And they put it into the crypto accounts. Now, on date 5, they discovered the scam, which, when the contact numbers for individuals 1 and 2 were disconnected. That was a mistake. The money was not yet safely out of the reach of probably the FBI to recover it and get the banks and the crypto operation to get it back, right? So essentially, they essentially said they discovered those contact numbers. They filed reports to government agencies and Bank A, and the agency, like I said, probably law enforcement, FBI, whatever, with the assistance from Agency B, and I expect Agency A may be the local police who probably contacted the feds, who then got in line with, stop the wire transfers. They secured amount 2 from Company B, that probably was where the funds were being currently held, and Company B was not part of the scam, but they're where the funds had been held temporarily, and companies are beginning to hold funds essentially because of these scams. You may find it moves slower. And on date 6, taxpayer A recovered amount 2 and explicitly represented that the amount that came from the IRA had not been used for any other purpose. It had basically been transferred, was on its way to the scammers, but they hadn't actually taken it, and they've still got the funds, and they're not using it for another purpose at this point. Now, taxpayers request a ruling from the IRS to waive the 6-day rollover requirement under Code Section 408D3 for that amount. As I said, this is where it's different from your client, because if your client doesn't have that amount, right, or at least other funds to replace it, it kind of doesn't matter if you get this ruling, because you don't have any funds to put back in. Now, the general rule is amounts due for an IRA are includable in gross income under 408A-D1. As we talked about, we talked about that chief counsel advice issue back in March about frauds in general. Generally, the money comes out of the IRA, it's taxable to the party, right? And it would be here. Now, under that chief counsel advice discussed back in March, in this case, they probably, if it was taxable, they would still be able to qualify for a deduction had they not recovered it. Recovered the amount, they're still qualified for a deduction if they had lost the money, because this would have been protecting funds that were there for an investment purpose. So they would have had a deduction, but you really prefer to have the money. And if you get the money back, you'd like to put it back in the retirement account, not pay tax on it right away. And so we're going to get out of paying tax if we can get the rollover approved. Now, that 60-day requirement, the inclusion of gross income, does not apply if your entire amount received is paid into an IRA or eligible retirement plan for your benefit not later than the 60th day after receipt. And there is the one time per year rule and other things you got to meet. Now, Code Section 408D3 capital I does allow the IRS to waive the 6-day requirement. If failure to do so would be against equity or good conscience. This includes situations involving casualty, disaster, or other events beyond the reasonable control of the individual. That's in the code. It applied to any distribution after December 31st, 2001. These are. Now, IRS issued Revenue Procedure 2003-16, talking about relevant facts and circumstances they would consider in granting relief. That includes financial institution errors, inability to do disability, and how they use distributed amount. Now, the problem is Revenue Procedure 2003-16 never really discusses this type of a situation, where the funds, again, they did voluntarily withdraw. Well, okay, voluntarily is probably stretching it a bit here, but literally from the bank's perspective, they voluntarily withdrew the funds. They thought the direction of a bank employee, but it wasn't. So, different problem. Can we still get the relief? Now, the IRS determined that the information and documentation was consistent with their assertion that fraud caused the failure to accomplish a timely rollover. And instead of going to the revenue procedure like they usually do in these cases, they now went directly to the code. That directly aligned with the events beyond the reasonable control of the individual criterion for a relief under the code. And so based on the code, this is why you read code. Based on the code, they waived the 6-day rollover requirement for distribution from amount 1 from IRA X. So what they do in a case like this, and this is why your client needs some money, they have 60 days from the issuance of the ruling letter to contribute that amount to the IRA. Now, as always, the amount says, because they put this caveat in here, they're not going to determine if there was an RMD required that year that wasn't made, because you can't roll over RMDs. And this private ruling may not be used or cited as precedent by anyone else, meaning you got to go get your own. You want to use your client just can't do this if they're scammed. Now, the good news about this is if you can get the money back, the IRS is willing to grant relief in compelling circumstances of fraud that prevent a rollover, right? It reinforces the equity or good conscience standard in the code when evaluating waiver requests. So that's useful. You have to have documentation, making sure the fraud's direct impact on taxpayers' inability to meet the 60-day deadline are thoroughly documented. We have here all kinds of police reports. We have them chasing down the money. We have lots of documentation now, which, when you're in timely and the law enforcement can move fast enough to get this stuff, you have lots of documentation. And you, of course, sign statements under penalties of perjury that you were defrauded, right? How this happened. So IRS is going to accept that level of stuff. So it's going to say. The downside is you've got to apply for a private letter ruling, which are A, not free, B, You're going to need, taxpayer almost certainly needs professional representation to go through it, which generally has to be paid for. That's the problem. If I don't have the funds, while I could get the ruling, what good does it do? I can't put money back in I don't have. Right? Therefore, I think in this case, and why we don't see a ruling like this very often, is recovery of the stolen funds was likely a key reason that made seeking this ruling a practical option for the taxpayer. You got to be able to complete the rollover. If you don't have the money, you can't, and usually scammers get all the money. Right? And part of the reason why usually by the time law enforcement comes in, it's too late, people don't like admitting to themselves they've been defrauded. In this case, what the taxpayer did, they did, say, hey, the lines aren't working anymore. I'm not going to assume there's just something wrong with my phone lines. And probably to some extent, the fact that they did do the overcomplication of having two different individuals working for two different entities, in theory, probably didn't help matters. When they went along with that, it's like it didn't really work well. It actually made it more likely, because why would both their lines go dead at the same time? Yeah, they should have probably kept the lines available, and quite often the scammers will keep the lines available until such time as the money's cleared out and the feds couldn't get at it anymore. And then suddenly they'll take the lines down. But obviously they got it. They were able to do it. So it is possible. Every time I've heard of a case like this, or even had a couple of clients that have had cases like this, by the time they admitted to themselves it was a fraud, everything was beyond retrieval level. You couldn't get it back, right? Didn't matter what you did, the bank, there was no way to get the funds. Everybody that could have gotten the funds had already sent them on somewhere. And eventually you hit a sent on somewhere that's not responding to anybody. Okay. So always advise client-specific requirements and the non-presidential nature of private letter rulings. So we'd have to take action. We have to do this. You got to pay the fee, and we got to pay for professional representation to take care of it. But it is possible. So if you get that unusual situation where they get the money back, but it's been outside the IRA for more than 60 days, it may just take more than 60 days for the money to come back. It's going to verify you really have a right to get it, you're the right person, etc. You can get a PLR and probably will get it issued. And keep this one on file, because if you do have that client who literally gets the money back, go for the PLR. And having this one is very useful because they're going to ask you to basically write the relief ruling. You pretty much have it here. You could do it. This has been the Current Federal Tax Developments for the week of September the 2nd, 2025. Current Federal Tax Developments brought to you by your state society CPAs. Again, I'm Ed Zollers. I do this every week. My email address, edzollers@currentfederaltaxdevelopments.com. I also are on Connect sites for a number of state societies. That is Arizona, New Jersey, Illinois, Idaho, Washington. So if you want, if you look me there or you have a question, I see your question there, I may respond to it. Otherwise, I plan to be back here next week. Yeah, because remember, this, of course, now is the short week, right? Since we had Monday off. Well, maybe you didn't have it off, but at least for most of the world, it was a holiday. So at least your clients thought you had it off. It means they shouldn't bother you. Hopefully they didn't on Monday, but whatever. We'll see you back here then next week. Look what's coming on. Remember, next week being the 8th of September, that'll put us 1 week away from the first drop dead due date. So hopefully you got your pass-throughs, putting them together, getting all the pieces together and are ready to file. And oh yeah, if you do have ones with 174A issues, hopefully you got time to get them reset and calculated the proper way, before you have to file that return on September the 15th. But, we got relief. It's just a little bit late, shall we say. We'll go for that. But otherwise, like I said, I will see you guys again next week on Current Federal Tax Developments.